Hi everybody, my name is Shannon Thompson and I am a pro bono special education advocate volunteering with Educate Advocate. We are a grassroots organization providing support and guidance for parents of children with exceptional needs. And although I'm not a lawyer, I'm hoping today that my experience as a COPA trained advocate will lend some insight into this really complicated process we're dealing with in our state for some of our families. So on a daily basis, Educate Advocate receives calls and emails from parents whose students with IFSPs, IEPs, 504s, and ISPs have been discriminated against by their school districts. And today I'm going to be covering a variety of questions we receive, try to give advice on how to navigate through these complicated scenarios with your district, and give you some next steps on how to educate both your district and your legislators. You can find additional information on our website as well as contact information for our advocates at educateadvocateca.com. If I don't cover a question that you left for us on our page, I'm going to do my best afterwards to go back and circle and around and answer everybody's questions. But if for some reason I overlook you, please send us a PM or a message. So let's start with the simplest scenario here. The simplest scenario is a child whose parent believes that they may need additional supports and services at school or at home, but they don't yet have any services in place. So if a parent suspects their child may have exceptional needs, at the age of 3, your local school district is responsible for evaluating that child. If your child is 3 years or younger, your local regional center is responsible. The school district cannot refuse to assess your child based on immunization status. This is very important. This would be considered a child fine violation. So what's child fine? Child fine is a federal mandate within the Individual with Disabilities Education Act, or in advocate speak we say IDEA, which states that if the district has a reason to believe a child within their boundaries may be a child with a disability, they must assess this child to make a determination if they're eligible for special education services. Similarly, if the parent of a child sends that school district a request indicating they believe their child may have a disability, the district must also assess your child. They cannot refuse, I'm going to say it again, to assess your child based on immunization status. This is a child fine violation. Okay, so let's move on to the next scenario, which is that your student doesn't have a medical exemption, your student doesn't have a PBE, which is a personal beliefs exemption, but they're currently getting some form of services, accommodations, or modifications provided by the district. Sorry guys, I have my cheat sheet here. Bear with me. So the youngest of those options would be a student with an IFSP. An IFSP is a special education program for a child who up to 3 years of age, and they may receive services and attend both private and state-funded early education centers without regard for immunization status. So I get a lot of calls and emails from parents saying, my preschool is private. They told me they can decide to set their own enrollment and admittance rules. Is that true? All licensed preschools and childcare centers must abide by our state health and safety code. The state health and safety code sets our immunization requirements and our exemption allowances. A private institution can't cherry pick which portions of the law they want to abide by. The health department would not let them decide to ignore the vaccination requirements. They're not allowed to ignore the exemption requirements either. So private child care facilities in the state of California are licensed and overseen by community care licensing, and this is underneath the Department of Social Services. Earlier this year, Educate Advocate spoke at length with the Policy Bureau Chief of Community Care Licensing, who indicated, along with their general counsel, that they do recognize that our current state health and safety code allows for students with both IFSPs and IEPs to enroll and attend private preschools without regard for immunization status. And in fact, Senator Pan's own staffer, Diana Douglas, clarified the intention of SB 277, which was the very first mandatory immunization law in our state, as being inclusive of students with IFSPs and IEPs. So I know if you go look up SB 277, you're only going to see individualized education plans, IEPs. The intention was for IFSPs to be included there, and our own state community care licensing department does recognize this. So moving on, if your child has an IEP, no ME, no PBE, just an IEP, which means they are 3 years or older, They cannot have their placement determined by their immunization status. Both our state health and safety code, sorry you guys, bear with me, and the IDEA, which is our federal special education law, requires that placement of a student with an IEP be based on the individual and unique needs of that student. And to the maximum extent appropriate, that student must be educated in the least restrictive environment, what we call LRE, with their non-disabled peers. Now, when can a student be removed from the general ed environment or the least restrictive environment? They can only be removed if their needs cannot be satisfactorily met with supplementary aids and services, not because of their immunization status. The IDEA requires your student is afforded a free and appropriate public education, so we call this FAPE, involving the student in and allowing them to make progress in not only the general education curriculum, but extracurriculars, non-academic activities to achieve their IEP goals. So the current and the future needs of your student must be considered here. Okay, to consider that means we're not just looking at their academic needs, we're looking at a breadth of developmental needs, social, emotional, interpersonal skills. So exclusion of an IEP student from the general ed environment based on immunization status is a denial of FAPE. It is denying the student the ability to confer an educational benefit from their IEP program, and it's imparting harm on that child. You can find more about this on our website. There is an FAQ there, and if you can't find it, just shoot us a message and we'll point you in the right direction. Okay, so moving on to the next set of services, which would be a 504. So unfortunately, this section of our state health and safety code that addresses IFSPs and IEPs does not explicitly call out 504s. So what this means is that school districts are currently excluding children with 504s who are not up to date. What does that mean for us? Well, Educate Advocate has been working diligently this past legislative session to get an amendment to that particular section of SB 277. Unfortunately, we did not get any legislators to pick that up. So students with 504s, in the meantime, are also afforded a free and appropriate public education FAPE. Now, the Office of Civil Rights, and that's a federal office, has issued us some guidance on this, and I'm going to read to you directly from this letter so that you, a parent of a student with a 504, can better understand the arguments you may want to make with your school district when they come to you and try to exclude your child. So our federal guidance from the Office of Civil Rights, or OCR, says, no otherwise qualified individual with a disability shall solely by reason of their disability be excluded from the participation in, denied the benefits of, or subject to discrimination under any program or activity receiving federal financial assistance. That's every public school. The Section 504 regulation requires a district to provide FAPE to each qualified person with a disability who is in their jurisdiction, regardless of the nature or severity of the disability. I get a lot of parents emailing me and saying, oh, but my child only gets extra time on tests, but they have a 504. Doesn't matter. We are not comparing whose disability is worse, so to speak, or more severe. All children who qualify for a 504 are on an equal plane there. All disabilities are considered disabilities, period, end of story. Students with disabilities and students without disabilities, this is for 504s, must be placed in the same setting to the maximum extent appropriate to the needs of the student with disabilities. And you probably remember hearing me say this about IEP, so it's extremely similar. A recipient of federal funds has to place a person with a disability in the regular education environment. Not a closet, not an office, not your home, a regular education environment, unless it is demonstrated by the recipient that the student's needs cannot be met with the use of supplementary aids and services. So we know for most children, this is not true. You can meet their needs in the general education environment. Being unimmunized or missing a booster, that doesn't constitute a reason for removal from general education. So what does that mean for your student with a 504 if they're currently being excluded? It may mean that your district is denying that student FAPE, and you can take proactive steps to educate your district about this or file appropriate complaints, and I'll talk a little bit more about that later. So moving on to the last set of services, ISP. An ISP is for a child that is in a private school setting. Now, the majority of that time, you're going to find that a child in a private setting has been parentally placed, meaning the district did not choose to place the child there because they couldn't meet their needs. The parent opted to enroll the child in that private institution. An ISP can be provided by the private school or more commonly via the public school district. And although your child's no longer entitled to FAPE, they may receive still some special education services and supports. So our state health and safety code does not explicitly address ISPs, just like it doesn't explicitly address 504s. However, an ISP is comparable to an IEP, but the student's just attending a private school instead of a public school. It's reasonable then to assume that a private school who chooses to include a student with an ISP, regardless of their immunization status, is no different than a public school choosing to include a student with an IEP, regardless of their immunization status. And here's what I encourage you to discuss with your private schools who are wavering on this topic. There is nothing in our current state health and safety code that directs a private institution to exclude a child with an ISP because they are not up to date. So what can you do if your child with one of the 4 programs I just mentioned has been excluded due to immunization status? You can file a variety of complaints depending on the type of program your child has. And if you have questions about that, please email us. Most of these complaints would be directed to the California Department of Education. Sometimes you can file a complaint with your district directly. And then, of course, the Office of Civil Rights for discrimination issues. You may also want to file for due process if your student has an IFSP or an IEP, but I do not advise doing that without the guidance of a licensed special education attorney because the odds are not in your favor as a parent, unfortunately. So let's move on. Your child with one of those services was told you have to go get a PBE or an ME, and rather than educating your district on these federal and state rights, you did go do that. Well, now what happens with the passage of SB 276 and SB 714? So let's start out with PBEs. If your student had a PBE exemption on file at the school, a personal beliefs exemption, and it was grandfathered, grandfathering for PBE means it was on file before January 1st, 2016, and it was on file within the first 6 months of your child's attendance in school. It means that they will be permitted to continue to attend until they reach a checkpoint grade of TK Kinder, which is really kind of not applicable here any longer because of the time, or 7th grade, whichever comes first. At a checkpoint grade, that PBE expires. It's invalidated. And in order to continue attending, your child must retain their special education eligibility via the IFSP or the IEP, or provide an up-to-date medical exemption. PBEs do not have any effect on special education, and they don't guarantee special education eligibility. So let's move on to the more complex issue, which is medical exemptions. And that is what these last 2 bills that were just signed in will affect. If your student with special ed services and eligibility had a medical exemption on file before January 1st, 2020, they will be permitted to keep attending, regardless of their special education eligibility, until they reach the checkpoint grades of TK Kinder or 7th grade, whatever comes first. Now, once they reach those grades, your medical exemption needs to be resubmitted, and it must adhere to the updated criteria in SB 276 and SB 714. What does that mean? I'm not an expert on this, and I highly recommend you follow a Voice for Choice for more specific information, but I'm going to try to summarize as best as I can here. The new criteria means it must be on a standardized form. It needs an explanation of how long that physician has been treating the child, if that physician is the child's primary care physician. If it's not the primary care physician, it must contain a statement as to why the primary care physician is not writing that exemption. It needs each immunization to be exempted pursuant to the CDC, AAP, and ACIP criteria. And it also needs to list whether the exemption is permanent or temporary. And remember, temporary can only last for 12 months now. It also has additional criteria, but as I mentioned, please follow up with a Voice for Choice for more specific questions there. So what happens if your child's exemption is invalidated at gradesman? Are there any other options or ways that your ME can be invalidated? This is important to know. So is your child safe, essentially, if with an ME right now until a checkpoint? No, your child is not safe just because you have an ME, because there are other ways that it can be invalidated. So if your physician who has issued the exemption has a pending accusation, or if the physician has been disciplined related to immunization standards of care, schools may not accept your exemption. The health department can come in at any time and scrutinize and review those exemptions and remove them. Now, there are a few other indicators that would cause them to come in and review. If your school's immunization rates fall below 95%, or if the physician who has written the exemption has written more than 5 a year, again, the health department can come in, review, and choose to reject those exemptions at any time. So yes, mid-year, that's possible. So now let's talk about what happens if you do get a new updated medical exemption for your student and you want to submit that. What does that mean? So the new medical exemptions will be submitted to a statewide database with the California Immunization Registry, we call it CARE for short. It requires a release of your authorization to permit the state to access your child's medical records with the physician at any time. For parents of special needs children, this is particularly important because our children's medical records don't just contain information about our children. They contain a lot of updated information about our family, our relatives, and our immediate family members. The CARE database currently has no opt-out. I know I get a lot of parents asking me, well, what about the lock form? Can't I lock my records? Yes, you can lock your child's records from third-party access, but a state health officer always retains the right to review that record at any time. It does not lock the state out of your child's record. CARE also has a multitude of end users, which I'm sure most people are unaware of. It includes correctional facilities, pharmacies, schools, hospitals, physicians, and state departments. And if we're talking about a security risk here, it's important to note that 94% of the data transmitted into CARE is done so indirectly using a third-party sending facility. So that increases the chances of a security breach. So as we talked about already, many of our students who have medical exemptions, these exemptions detail their specific diagnosis of not only themselves, but their immediate family members. Sometimes it includes neurological impairment information, physical disabilities, severe allergic reactions, genetic information, and so on. With the data breach and security a very real and palpable concern, we have to consider the possibility that release of this information could result in discrimination of not only our students, but our own family members by higher education institutions, insurers, and also employers. So what can we do to protect our student records? The Federal Family Educational Rights and Privacy Act, FERPA, is what applies to our student records. I have a lot of parents say to me, but my medical exemption contains medical info. Isn't it protected by HIPAA? Nope. Once you submit it to the school, it is no longer protected by HIPAA at the school. It's protected by FERPA. So FERPA and another statewide statute called the Confidentiality of Medical Information Act, CMIA, provides some protections for our students' educational records. So under FERPA, schools can only share medical records of a student to meet legitimate educational interests. So how do we know it's a legitimate educational interest? The school has to give you an annual notice of what their criteria for determining what a legitimate educational interest is. So you can always go to them and say, well, you released this, so I want to see what your determination of a legitimate educational interest was. FERPA also says that you cannot allow routine disclosure of student records in situations that are non-emergencies. Immunization records, medical exemptions, not emergency situations. We do not need to be disclosing this information to our state health officers in a non-emergent situation. So, flip over here. Sharing medical information under the CMIA. So sharing medical exemption information with a public health officer could also constitute a violation of the CMIA Act because California law prohibits the disclosure of such records that contain a student's medical information unless the parent has first provided a detailed authorization for release of information. So if your student's record has been released, you need to go to your school, remind them of this, and ask them, where was your detailed authorization of release that you signed? And parents, when you're signing your kids up for school, please read through everything you're signing. A lot of times you're going to have those releases included in the 6 or 7 forms you're signing off on. So it is really important you know exactly what you're signing. Now, if your school is found to have committed a CMI violation, or your school nurse rather, because it would be a covered health entity essentially, they can be fined. So what can you do if you believe your student's privacy has been violated? You can file a FERPA complaint with the U.S. Department of Education about your district. Now, how can you prevent these records from being disclosed from the state? I'm going to give you a cold, hard truth here. You can only decrease. You're not going to be able to prevent entirely. There is no fail-safe option I can give you here to tell you that your student's records will not be accessed by the state. If you file an objection to disclosure of information, and you can find this on a Voice for Choices website, it may give your district pause before they choose to release your information to journalists or to the state. It's not going to prevent it altogether, but it might give them a moment of reflection and cause them to push back a little bit harder and ask questions about whether or not what they're doing is within the law. So now let's talk about the fact that most of our students in California who have the plans that we've discussed, IFSPs, IEPs, 504s, and ISPs, constitute a student with a disability under various laws, federal and state. So what does it mean when our disabled students are excluded and discriminated against? So I've heard so many parents recount stories of their children's private medical information being questioned and discussed in the front school office with the parent in front of other administrators, teachers, or students. I've read public record requests from districts that disclose the name, the physician name, and the medical conditions in the schools of different children that attend within that district. I've been questioned by district officials when advocating for students, demanding to know why a parent didn't get that extra booster or why they're choosing to delay these immunizations. And I've also been told that some students are being taught and receiving therapies and services at local libraries and parks. The reason I'm telling you this is because there is one common thread through all of this, and that is that these schools are discriminating and segregating our students who are afforded federal and state protections. So what are these federal and what are these state protections? The ADA, the Americans with Disabilities Act, the California Civil Rights Act, and in California we have what's called CalGINA, California Genetic Information Non-Discrimination Act. How do these apply to our students? So both the ADA and the Civil Rights Act of California have provisions that prevent discriminations based on disability. The main difference between the two is that federally speaking, ADA requires that your disability substantially limit a major life activity, and California has a little bit of a lower bar. So our state Civil Rights Act requires that the disability limit, not substantially limit, just limit a major daily life activity. Now, what's a major life activity, for a 6-year-old? Major life activity is broadly construed under the law. It includes physical, mental, and social activities as well as working. So that would encompass their educational experience at school. Now, who do these laws apply to? They apply to, in the most part, some private institutions, but all public institutions. So let's go into ADA first. What are our possible ADA violations? So this could vary depending on your child's diagnosis or the medical condition that warranted the exemption. For example, recognized disabilities under ADA do include epilepsy, physiological disorders, and conditions that would include skin, endocrine, and mental and psychological disorders, also emotional or mental illness, and specific learning disabilities. So that's quite an extensive list. The ADA clearly defines what's not a disability, but the burden of arguing what is a disability and what is a substantial life impact would fall on the parent and the physician. So some of the issues that I've seen raised that I think fall under ADA would be direct threat. And you'd be shocked to hear that I have had special education directors at the district level say to me, I can't admit this child. He's a threat to other students. A child who may be missing just a single booster. So what does this mean? So ADA acknowledges that some disabled people pose a direct threat to others. So for example, a student with HIV or hepatitis B. But the decision to exclude a student cannot be based on an elevated risk of injury because others perceive them to be a risk. In essence, both the ADA and 504 require that decisions about who is a threat to public safety has to be based on an individualized assessment and objective facts. It has to include the nature, the duration, the severity of risk, probability that an injury might actually occur. And it states that this determination cannot simply be made by an employer or a supervisor or a teacher or a coach. It needs to be made by a health risk arbiter, a medical expert using up-to-date information. So that's one area where we can argue with our schools. Are you calling my child a direct threat? Are you excluding them based on your perception of their ability to cause risk or injury to another student by passing along a contagious disease that they do not currently have and that they are not currently exhibiting any symptoms of? The next section of ADA violation I want to discuss pretty much applies specifically to private entities, and that would be eligibility criteria. So many of the private preschools and other elementary level schools that I mentioned earlier have written policies or sometimes have made statements to parents specifying that children with MEs can't even apply. These policies are intentionally implemented and applied to screen out disabled students with exemptions and may constitute an ADA violation. The ADA says that you cannot apply additional eligibility criteria to student enrollment that would effectively discriminate against a subset of disabled students. So we have under ADA, direct threat and eligibility criteria. So now let's move on to our own California State Civil Rights Act, This California Civil Rights Act defines disability as including medical conditions with genetic characteristics. So let's talk about all these genetic tests that so many of our children undergo and are acquiring via our physicians to get medical exemption screenings. What is a genetic characteristic under the law? So genetic characteristics under our State Civil Rights Act says any scientifically or medically identifiable gene or chromosome, a combination or alteration thereof, known to be the cause of a disease or disorder in a person, that person's offspring, or determined to be associated with an increased risk of a development of a disease or disorder. Why is this important in our state? So as I mentioned earlier, California has what's called CalGINA, California Genetic Information Non-Discrimination Act. Why are we talking about this in relation to our State Civil Rights Act? Well, many medical exemptions document thorough genetic testing in order to identify predispositions to various diseases, illnesses, disabilities, and more, which could be exacerbated by immunization. And we know that as these exemptions are submitted to the CARE database, there is a high possibility that many of these will be rejected based on the new narrow criteria. Did you know that in our state, every newborn born in California is screened by the California Newborn Screening Program for a category called amino acid disorders, and under which there is a subcategory called remethylation defects, and under that is MTHFR. So I bring this up because our state recognizes that MTHFR mutations are important enough to screen all newborns for, but our CDC, ACIP, and AAP contraindications to immunization make no mention of any genetic information or genetic screening or so on. The standard of care that we are now facing to qualify for a medical exemption is light years behind the science of genetic testing and out of step with our own newborn screening program in the state. So again, why is this important? In California, discrimination of an individual based on their genetic information is prohibited via CalGINA. CalGINA's protections extend to students in public schools and some private schools. And CalGINA also went so far as to amend our own state education code to ensure schools have access to more resources so they can more readily combat genetic information bias. Now, many of you might be thinking, like, this is super complicated. This hasn't happened before. I don't want to be the first to bring this up. I want to let you know that in our own 9th District court system, there was a case that went through in Palo Alto. It's called Chatham v. Palo Alto Unified School District. And in this case, a student during a newborn screening test was identified for having genetic markers for cystic fibrosis. The student did not have active cystic fibrosis. The information was shared with other parents of medically fragile children at the school that this child attended, and he was excluded from the middle school based on the genetic predisposition. Despite settling with the school over the original injunction the parents filed, the family decided to sue in federal court, claiming that the school had violated ADA law. So now think back to everything I just said about ADA and direct threat and additional eligibility criteria. Specifically, the parents in this case argued that the genetic information was consistent with a certain disease and it constituted a perceived disability under ADA. Our Ninth Circuit Court of Appeals rejected the school district's motion to dismiss and allowed the ADA claim to proceed. So I believe that this family has since settled, but this is very interesting precedent for us in California when we're looking at our children who have genetic testing associated with their medical exemptions and who've been excluded from school. This may be a CalGENA violation. Okay, so almost done, guys. Thanks for hanging on with me, and I hope this helps answer a lot of your questions. As I mentioned before, options for filing complaints. We had the Office of Civil Rights, the California Department of Education, the U.S. Department of Education for FERPA violations, and of course your own school district. And if you need guidance on how to write a complaint or who you should be filing with, please email us and we will try to help you out with that. So now I want to discuss next steps. I want to encourage everyone who's watching this to take proactive steps to prevent discrimination of your students so you don't find yourself in a situation where you need the help of an attorney or an advocate to ensure that your child's inherent civil right to equitable education is being met and provided by your school district. So how do you do that? Contact your legislators, please. Many of our assembly and state legislators who voted for SB 276 and SB 714 had no firsthand knowledge of how these laws impact our disabled students in the state. In fact, the majority of them felt that they were protecting these students by voting for these laws. If your child is being harassed, excluded, discriminated against, and it has one of the many special education or service programs that we mentioned, please reach out to your legislators. CC them on your communications with your school districts, your advocates, your complaints. Let them see that you're filing complaints. Meet with them. Share your experience. Give yourself a voice and a face to the very real discrimination that these children are suffering every day. Ask that your legislator commit to amending our current health and safety code to be clear and include all students with disabilities who are being impacted by these laws. So that's your first step. The second step is that we need to start speaking up with our schools. Our schools have been complicit with these laws and our state offices for too long. If your student with an IEP or an IFSP has a medical exemption on file now, don't wait until these new laws go into effect. Do not try the wait and see approach. We don't have the privilege to wait and see how these schools are going to interpret the law. We know from experience with SB 277 that the law is not clear and that districts will, without a doubt, implement the law unequally, and our students are going to be the ones who bear the brunt of this ignorance. We cannot allow our children to go without their therapies, their services, their access to education, and we need to start demanding equity from our districts. Email your district, meet with your superintendent, attend your school board meeting, and speak up. Educate other parents. You will find a tribe that you did not know existed because for so long, so many have been afraid to make waves or wanted to stay under the radar. We need to speak up, identify each other, and band together to support and educate our school districts now. We need to highlight the potential liability for our school districts and discrimination associated with excluding our students and the potential adverse impact they are causing these students. Talk to them about FERPA. Talk to them about the CMIA. Let them know a large number of parents in your district will be seeking reparations if they choose to be complicit with requests from journalists and state agencies looking for medical exemption information, and they don't have valid merit to be requesting this information. Educate Advocate will soon be putting out additional template letters so that you can reach out to your legislators and your school districts. And we hope that you will speak up and speak out with your fellow parents on behalf of the 12% of children in California currently receiving special ed services and the millions more who we know have gone without, who've been overlooked by their district and denied by our public educators who should be serving their needs. So we're asking for your help and support today in educating our legislators, our other parents, our fellow parents, and more importantly, our school districts. We need their help. We need to form a team, and we need to start working towards inclusivity of these children. So I will circle back now and try to get a hold of all of those parents who've been asking questions on our page. And if you have an additional question after this, please reach out to us and we will get back to you as soon as we can. Thanks, and I hope this was helpful.